you, Madam Chair. My name is Jack Fisher. I'm from Sherwood, and I'm representing the Talbot County Republican Council today. Question when you consider any bill on the way to being legislation is whether it's a good public policy. So the question today is Bill 1298 good public policy? Is it good public policy for a county to give up, to surrender, willingly, volunteer to give up its ability to regulate its own land? Does any county council ever do that voluntarily? Any Republican county council ever consider doing something like that? The core belief of our party, the central plank of who we are, is local control. That local control is a better way to govern than remote control, than from some cubicle up in Baltimore, in this case, over our non-tidal wetlands. It's almost incongruous to see a bill like this before a county council. What county council would consider voluntarily giving up control of land of its citizens? Now, we spent an hour and a half with Mike last week discussing this subject, so I know that Mike believes that we are preempted from dealing on our own lands in terms of non-tidal wetlands. But his conclusions are in dispute. Now, let me say, first of all, I've dealt with Mike for over a decade, and I have great respect for him, and I respect his opinion in this case. But his opinion, his conclusion in this case, is in dispute by a number of intelligent men and women who are knowledgeable in the law. That includes the attorney for the Board of Appeals, our entire Board of Appeals. And these people deal every day, every time they meet, with the county code and the state code. They know it cold. And they don't make decisions without considering those codes. Their decisions are based on those codes. These are knowledgeable people. And then there's nothing to say, there's nothing more to say than Judge Wise in the circuit court, who also disputes Mike's call on preemption. So there's a great road open. There is space open to doubt this Mike's conclusion that we have no authority to regulate our own non-tidal wetlands. And counties do not give up local control if there's those kinds of doubts in place. There are other ways to consider this thing. So these men and women who have made these decisions, the Board of Appeals, Judge Wise, and the attorney for the Board of Appeals, have considered the same facts that Mike has, have looked at the same county code that Mike has, and they've arrived at a different conclusion. So it isn't clear at all that we need this legislation now to voluntarily give up local control. We have, it wasn't long ago that we had control of our tidal wetlands, and the state seized control of our tidal wetlands and our critical area, and they came down on us with the critical area regulations with which we've been bedeviled for the last 5 years. We have our own Blue Ribbon Commission that's been dealing with them and with our own citizens, trying to find a way to improve our ability to work in that land. We have lost real estate deals because of it. We've lost construction deals because of those regulations. We're still struggling with them now. And now this bill offers to give them 11,000 acres of our non-tidal wetlands to deal with. What mischief might occur if we do that? In sum, we don't give up local control. The citizens of this county elected you to regulate our lands. The last thing they would have expected is that you would voluntarily pass that responsibility on to the state. I ask you to reject this bill.
Good afternoon, Sean Callahan. I'm here representing myself for engineering. All this bill does is give a person the ability to avoid the Board of Appeals to get an approval. This bill has a direct effect on my business, and it affects the perception and reality of doing business in Talbot County from a development standpoint. My talking points, if you want to follow along, Mary Kay's right, non-tidal wetlands and wetland buffers have to be delineated on the ground. Those criteria are investigated by the planning office and also by the Army Corps of Engineers and Maryland Department of the Environment as part of any project. The definition of wetland changes from time to time. Most folks in the public don't recognize that, but loblolly pine and holly were reclassified by the federal government as wetland species recently. So areas that were not formerly wetlands and the buffer that projects from that are now wetlands. No zoning ordinance change, but a federal definition change. Non-tidal wetland buffers are not habitat protection areas under the zoning ordinance. And that zoning text is attached here. And I'll point you to it. You've heard non-tidal wetland mitigation, and non-tidal wetlands must be mitigated if they're impacted in the critical areas. There is no mitigation requirement for non-tidal wetland buffers in the critical area or out of the critical area. So that tells you that they are protected. Everybody wants to know about them and identify them, but they don't have the level of protection under state and federal rules as other buffers or wetlands themselves. Talbot County began to regulate non-tidal wetland buffers, I believe, in 2009. Zoning ordinance section 190-140, I believe, came into being in approximately 2009. And this was about the same time that the 200 and 300 foot buffer regulations came in, the tree planting regulations came in, and the living shorelines regulations came in. And it's also when the economy had tanked. So no one in the development world was looking at the changing regulations to the degree they do when things are busy, because everybody had their head down just trying to stay afloat. And this piece of the ordinance, I believe, came in 2009. And as I follow up on this, no one can really tell me where it came from or when it happened. Maybe we can get to the bottom of that. No other adjacent counties have this additional protection of the 25-foot non-tidal wetland buffer. It just doesn't exist anywhere but Talbot. And then there's a little bit of a conflict in the ordinance. If you're in the non-critical area, the wetland buffer may be impacted if the county says it's okay, or if there is no other reasonable alternative. In the critical area, you have to go get this variance. The hardship regulation for a variance says that without a variance, the property must be unusable. So the rules also say that you can't create your own hardship and ask for a variance. So theoretically, the Board of Appeals can't give you a variance if you make application for subdivision, because you're creating your own hardship by asking for the ability to put lines on paper through a non-tidal wetland buffer. To complicate matters, the variance is only allowed to be requested at the end of the subdivision process. So you go through whatever number of submittals to the county and discussion, and you get to the end and they say, well, now you need a variance. Well, we wish we could have asked for that up front. Yeah, but the Board of Appeals won't let you ask for that until they know everything else is squared away.
If you could wrap it up, please.
You get to the end of your project and a possibility of a denial exists. And that's what scares investors and developers. It's the unknowns that are undefinable, but only in Talbot because of this regulation.
For the record, Tom Allsbach, I'm speaking on behalf of Robert and Kathy Magdaleno, who are citizens of Talbot County and Talbot Preservation Alliance. So I would request 5 minutes, Mr. Timekeeper.
That's fine.
You have, ladies and gentlemen of the council, thank you for this opportunity. You have been advised that it's required that we give up Board of Appeals jurisdiction over non-tidal wetlands because of this doctrine of preemption, which supposedly means that once MDE issues a permit for activities in non-tidal wetlands, this local government cannot act in any way that would affect that permit, and the MDE's judgment is final. Now, in addition to what MDE's regulations say, we now have a court decision on this subject of preemption. In that court decision, which arose from the Board of Appeals denying a variance in order to construct this open sewage pond in a non-tidal wetland, in that circuit court proceeding, the question of preemption was squarely presented. I have the brief of KES Farms right with me. The very first point they raise is that the Maryland Department of the Environment permit preempts the Board of Appeals from requiring a non-tidal wetlands buffer. Extensive argument occurred on that before the circuit court judge. I have the circuit court judge's opinion right here. On page 5 of this opinion, Judge Wise ruled that there are multiple reasons why preemption does not and should not apply here. The court goes on to quote from the Maryland Code, which states that notwithstanding the approval and MDE permit, the applicant must still comply with all other local zoning and local regulations. So we have a court decision, we have MDE's regulations, both of which clearly state that we are not preempted from considering variances through our Board of Appeals. I understand that you've been advised there's other language in this circuit court opinion which suggests the judge was not trying to make a comprehensive ruling on preemption. I get that. But he had to address that issue of preemption in this case because he had to decide, and he did. And he decided on the basis of there being no preemption under applicable Maryland law in the instance of this case. Why would we want to give up local control over our non-tidal wetlands to our Board of Appeals? Statutes, the provisions that are challenged by this legislation, what we're proposing to amend, they've been on the books for 20 years. No one has ever suggested, no lawyer for the county, no council member, no one else that I know of has suggested that these provisions that are now in force are contrary to state law. This has only come up because of the fact that we're faced with a situation where a disappointed applicant who did not obtain a variance is now threatening to bring a takings action against the county. And that's what's driving this. We shouldn't be making public policy based upon threats from litigants and lawyers. Why would we want to give up the additional controls we have through our Board of Appeals, which considers a lot of factors that are important to local citizens that MDE does not address in their permitting process? For example, one of the variant warrants that the Board of Appeals has to address is whether the proposed work or construction that's been requested will have any detrimental effect on the public and on adjacent properties. That's a local requirement that we ought to have in place to protect our local citizens. In this case, it was used to protect my clients and another individual whose property is adjoining a non-tidal wetland where they want to construct an open sewage pond in their backyard. I would urge you not to adopt this legislation at this time. I do agree with one thing that Sean Callahan said, which is a lot of issues here, and it's worthy of a work session or further discussion before we go ahead with this. Thank you very much.
Yeah, we're going to hold the written comment open until Friday afternoon for anybody that wants to submit additional comment. And we are going to make this eligible for a vote on Tuesday, March 24th.